Good on them. If they don't, why should they?
Honourable David Parker.
Mr Chairman, by 2027, 1 million New Zealanders will be over the age of 65. The Minister... Beg your pardon? Yeah, I am. Sorry, look, actually, just as Jackie Dean and everyone else in the National Party seem to be in denial as to the need to be fiscally responsible in terms of the number of people who have to be paid superannuation, this number of people is also relevant to this debate. The Minister has not addressed the issue as to what is the principle that lies under our jury laws. The principle of jury trials is that an accused has the right to be judged by a panel of their peers, a representative group of society. The Crown, prosecuting someone in a jury trial, has the right to have that trial determined by a jury made up of peers out of the community who are representative of members of the community. As the population ages, a greater proportion of those people are aged 65. Those people ought to be part of the pool of people who are conducting jury trials. The arguments in favour of giving people a one-off exemption are already well traversed and they're already covered in the law. If you've got a disability, if you've got some work commitment, or it might be a childcare commitment, looking after your grandchildren if you're over the age of 65, you can already write into the court and seek delaying your obligation to serve on a jury, to be on a panel and be in the ballot until a later period. And if that inconvenience if that case is made out to the registrar or to the judge, if the registrar doesn't agree, then you won't be on the jury. It's a pretty good threshold already. But what this amendment does is say that someone from that age cohort can withdraw themselves from the pool forever, despite the fact that they may be very competent, that they might have more spare time in their life. Oh, it's about choice, Jackie Dean says. So choice for the person over 65, not choice for the Crown, not choice for the accused, and not the same level of service or obligation required of people who are under the age of 65, despite the fact that the only difference between the person under the age of 65 and over the age of 65 in some cases will not be capability, will not be time availability, it will only be the age. There's no logic that lies behind this. So not only is it discriminatory from the point of view of the Human Rights Commission, it's actually wrong in principle, because the principle is that in respect of a jury should be collected from the population, that should be collected from people who are representative of the community. As our population ages, as people live longer, a higher proportion of our population are aged over 65. And the effect of this amendment, if it proceeds, is that by 2027, 1 million people will be able to permanently exclude themselves from being available for jury duty. And that, to me, is a very strong argument as to why this piece of legislation is flawed in that regard, because I want juries in my country to be representative of New Zealand. If people have a disability, or if they can't attend because they've got some other obligation, yes, they should be allowed to, if they've got a permanent disability or they're permanently incapable of, because they're aged or infirm, they would have a level of disability that would entitle them to permanent excusal anyway. But if they're not, if they're capable, if they have got their full capacities still, if they have the time to be on the jury and haven't got a work commitment that lets them off, the person should be available for jury service. That is one of our duties as people in society. We might not like doing it. We might have to confront some pretty unpleasant facts on juries at times, but it is part of the civic duty that we all have, that we have all had for centuries in the English tradition of law that we have and should strive to uphold in New Zealand. So I thank Dennis O'Rourke for his amendment. I think he is right that there should be no automatic extension. Indeed, I suggest that the existing right of repeatedly applying for an exemption without grounds is wrong, and that should, Mr. Speaker, Mr. Chairman,
David Parker.
and that should in turn be tightened so that it is on similar grounds to those people who can be excused because they've got other commitments or suffer a disability. So, Mr. Speaker, not only is there something in the Human Rights Commission advice that this is discriminatory, it strikes against the fundamental principle that underlies juries, which is that they should be representative of the community. And if I was an accused and I was charged with a particular crime, I actually might want to have a jury that had a number of people that were over the age of 65. And at the very least, I would want the people who are impanelled that come before the lawyer acting for me, and I've got a right to challenge a certain number. I would want a number of those people in some cases to be mature, to have seen life. They might have a slightly different viewpoint to a younger cohort of people that I think might be more relevant to the issues that were at large if I was being charged with a crime. And I think that my rights as a New Zealander to have a fair trial include the right to have a jury made up of people who are representative of the age cohort, including people aged over 65. Similarly, if I was the prosecution, I can see cases where, as a prosecutor, I would have a similar view. So my greatest concern about this is that it infringes the underlying basic principle of juries, that is, that everyone who is competent and available and doesn't have a good reason should be available for jury service, and being over the age of 65 is not a sufficient reason for being excused of itself. If it's associated with a disability or some other a disability that's long-term, you can already get out of it. I think I've probably said enough, Mr. Chair.
Mr. Side, Mark Mitchell.
I move that the question be now put.
Andrew Little.